This court is so raggedy, bruh. We could just randomly add like the smoke detector alarm, and I think it'll go by exactly as we think. Like if I added a smoke detector alarm randomly in this video, don't it sound like it'll just make sense? Man, let's get into it.
So this is yours. That's me. There's no sound.
Okay. All right.
But if you click the next one,
Okay.
it's popping up over there.
Thanks. Okay. Is there anything added to this one that isn't captured in the still other than a good beat?
You just created a soundbite.
That's that laugh you give your mama or your daddy or whomever, in my case, my grandma. That laugh you give them about their jokes when you want to go out or you want to ask for something that you know more than likely they're going to say no to. So, yeah, no.
And, this meme, we would argue, is relevant. You're about to get 20 years for a crime your best friend did last night. Do you snitch or take the beef? You tell the punk ass police to do their fucking job. So Mr. Sledge, in his interview, he essentially said as much. On his video that the court heard a moment ago, he intimated as much. But what he's doing in this particular posting is making a public proclamation displaying their belief towards snitching. You have not only Mr. Sledge making that lie to their mama, lie to their sister, get into court and tell the God is on his truth. You have Mr. Williams, who posted a similar video with Mr. Sledge apparently in the background, mumbling, saying, sort of signing on to whatever it was that Mr. Williams was saying at the time.
Maybe that'll be my preliminary ruling, subject to revisiting. Okay.
And Judge, there was one other thing. I don't know that it'll have any bearing on the court's ruling, but in that instance where Mr. Stillwell, where the drugs were found in Mr. Stillwell's cell, there were, Miss Hilton pulled up the photograph that I asked her to, and there was a shank.
Is the shank inscribed YSL? Then it doesn't.
No.
I mean, it makes Mr. Stillwell look bad, but it's not intrinsic.
Yes.
Okay.
Your Honor,
Yes.
if I may,
Yes.
before you make a decision on the one alleged intrinsic act that was referenced by the state involving the supposed passing of a Percocet pill from Mr. Khalif Adams to Mr. Williams, I would ask that the court at least go and take a look at the video that was referenced by the state. I think it's instructive. I also think that well, fortunately for us, paints a different picture than was recited by Madam Prosecutor. I think the events did not occur in the manner that she referenced. I was present. I was sitting right next to Mr. Williams. I think the video will show something being passed to Mr. Williams, not him hiding his hand underneath the table or bringing it out and then giving it to the deputy, or the deputy saying, give it here. It didn't happen that way. And I think that goes into the analysis of exactly what happened.
All right. Why don't you just tell me what you recall or what you think the video shows?
Sure. What I recall and what I know happened, because I was sitting right next to Mr. Williams in the front of the courtroom, is that there was a break. Mr. Adams, who was sitting in the rear part of the courtroom, came up, and as he was going towards that door, goes as though he's going to give Mr. Williams a high five or a dap or something like that, and put something in his hand. There's a deputy who's standing about 2 feet in front of Mr. Williams. Mr. Williams looks surprised. Mr. Williams has it in his hand and puts it down on the table immediately. There is no putting hand under the table to try and conceal it. The deputy, who I was within earshot of, did not say, give it here. Mr. Williams looks at it and puts it down on the table, and that's it. Okay. At which point Another deputy sees Mr. Adams and either takes him, I don't remember if they took him in the back or brought him back here.
Okay.
He was searched in the back, as I understand it. I think court recessed after that because of those occurrences, but that's how the incident actually occurred.
Okay. Can y'all send me that video?
We Yes, and
Okay.
and the deputy, the lieutenant, would also be a witness
Okay.
to what I'm saying.
All right. Well, I mean,
The version
I would
I'm
imagine the video shows what happened. So.
It does.
It does indeed speak for
All right.
itself.
Well, that's something we need to turn to as well.
And to give just a quarter reference, it would be after witness 91. And this is when investigator Viverito comes up, probably her third or fourth time. So
Have y'all given thought to streamlining your witness list and your evidence?
So, Judge, just so that the court is aware, early on, I don't know how familiar the court is with the number of witnesses that we initially started out with, but we started out with over 700. And before, I believe, Mr. Weinstein filed his first motion to limit the state's case with the former trial judge, the state announced to defense that not only would we actually be asking for an earlier start time and a later finish time, but we actually told them that we had reduced our list from the over 700 to just over 200. And we've reduced it further. And then after that was when I believe Mr. Kendrick filed a motion to force the state to reduce its list, but we had already said and done that. So now we've reduced it even further. And I believe that we are at that point where we've reduced it. The delay that Mr. Kendrick referenced in his motion has not been attributable to the state. We have had a number of administrative days. We have had a number of delays that were caused for other reasons that had nothing to do with anything that the state's case entailed. So our case and the length of our witnesses is not prolonging this trial at all. And our position is that we have streamlined it considerably. We continue to streamline it even after our first streamlining that we apprised them of.
All right. Well, all I'm saying is please try to do what you just said you are doing, which is continue to streamline, and I don't have the entirety of who's saying what to what, but you do have the thing that says what counts each witness is going to go to. Just make sure that you're not being cumulative in that the witnesses you're calling are basically worth calling, that they're going to add something material to the jury's ability to decide this case.
And Your Honor, we have indeed been doing that. I think that the main cumulative objection has come from as I remember, they've argued, well, they've called a gang expert, 3 gang experts, and that's cumulative. But each gang expert has talked about a different set of information that they have knowledge of. And they also had factual information that they were both fact witnesses and expert witnesses.
But you're expecting 2 more gang experts?
In terms of new ones? There were 2 left on the list that we haven't yet gotten to.
Right. So
one of them we may not call.
Okay. Well, you would need to be able to express what it is that expert or those 2 experts is going to offer that hasn't already been covered by the 3 that have already testified.
We would.
Okay.
And Your Honor,
Motion to time limit state's case due to prosecutorial unpreparedness and inefficiency, undue delay, waste of time, and or needless presentation of cumulative evidence. The defendant, Diamante Kendrick, by and through his undersigned counsel, without waiving any other rights to which he is entitled, files this motion to time limit state's case due to prosecutorial unpreparedness and inefficiency, undue delay, waste of time, and or needless presentation of cumulative evidence, stating the following. As this court has broad discretion to exercise reasonable control over the presentation of witness and evidence, the court should use that discretion to prevent this trial from stretching indefinitely and beyond the reaches of time due to the state's unpreparedness and inefficiency and presentation of cumulative evidence, causing undue delay, poor decision-making by the jury, as well as harm to Kendrick and other defendants. Simply put, the court should put a reasonable time limit or clock on the remainder of the state's case. The state has put and continues to put this court, these defendants, and these 16 jurors through an arduous, tedious journey. The court should put an end to our forced march, even as the state will likely contend that we should blindly trudge on in, trust that the next months will be different, that the state will develop the speed and efficiency of our finest Olympic athletes. Yo, that's petty as hell. And that this finish line of a snail-like marathon is in sight. Yo, I'm sorry, yo. At this point in time, this honorable court has borne witness to the state's unpreparedness and lackadaisical attitude towards any type of diligent approach to moving in a deliberate fashion toward a conclusion. But why should the state have any need to move with deliberate speed? The state returns home to their friends, families, and loved ones at the conclusion of each day. The state lives their lives, go to work, and gets their paychecks no matter how long this trial proceeds. Meanwhile, for Kendrick and the other defendants, every day is Groundhog Day. But instead of waking up to Sonny and Cher, he wakes up to a cacophony of Rice Street and the ritual of heading to court. The U.S. Supreme Court has explained the critical role of the trial judge in a criminal case. Our cases have consistently recognized the important role the trial judge plays in a federal system of criminal justice. The judge is not a mere moderator, but is the governor of the trial. For the purpose of assuring its proper conduct and of determining questions of law, a criminal trial does not unfold like a play with actors following a script. There is no scenario and can be none. The trial judge must meet situations as they arise, and to do this must have broad power to cope with the complexities and contingencies inherent in the adversary process. To this end, he may determine generally the order in which parties will adduce proof. His determination will be reviewed only for abuse of discretion. The judge may refuse to allow cumulative, repetitive, or irrelevant testimony if truth and fairness are not to be sacrificed. The judge must exert substantial control over the proceedings. The state, after originally proposing a witness list of over 700 witnesses, has a list of over 100 witnesses it still intends to present at trial. What specific evidence the state intends to use with each respective witness remains unclear. A very generalized description of subject matter to which each witness will testify has been provided. No end to the state's case in chief is in sight. This is simply untenable for the remaining 16 jurors or the defendants who remain jailed without bond, and the presentation of another 100 witnesses by the state would cause undue delay, would be a waste of time, and would amount to needless presentation of cumulative evidence, as put so succinctly by the Third Circuit of Appeals. Courts need not to allow parties excessive time so as to turn a trial into a circus. After all, the court's resources are finite, and the court must dispose of much litigation. In short, the litigants in a particular case do not own the court. Likewise, the prosecution here does not own this honorable court. This honorable court has broad discretion on the presentation of evidence and should limit the introduction of duplicative or unnecessary witnesses by the state. As noted by the Georgia Supreme Court, OCGA 24-6-611, A2 provides the trial court with broad discretion to exercise reasonable control over presentation of witnesses and evidence to avoid needless consumption of time. Newman versus State. The Fifth Circuit, the predecessor to our 11th Circuit, has also recognized the ability of a trial court to limit the number of fact witnesses at a criminal trial where those witnesses' testimony would have been cumulative. Furthermore, this court can limit evidence under Rule 403 of our state's rules of evidence. Relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. GA Code N 24-4-403. Thus, there is also a basis under either Rule 611A2 or Rule 403 for this court to exercise reasonable control and discretion in placing a time limit on the state's case to prevent undue delay, waste of time, or be a needless presentation of cumulative evidence. It has never been supposed that a party has an absolute right to force upon an unwilling tribunal an unending and superfluous mass of testimony limited only by its own judgment and whim. And exercising its reasonable control over the presentation of witnesses and testimony, Kendrick also urges this court to consider the ramifications of the present pace of the trial and its impact on the jury, the case, as well as the defendants. While there is no doubt the new court is moving this case along at the fastest pace possible, given the court's meritorious recognition of the limited recognized right of the state to present its case in a manner it deems best, the prospect of another 100+ witnesses leads to several undeniable conclusions. This trial will last well into 2025 if the state is permitted unlimited time to present its case. Courts outside of Georgia and the 11th Circuit have recognized the impact on a jury of a lengthy trial merit consideration. For example, the 7th Circuit has approvingly quoted, exceedingly lengthy trials lead to reduced concentration and recollection of events on the part of all participants, particularly witnesses and jurors. In very long cases, exhaustion may diminish everyone's performance. The quality and representative nature of the jury may be reduced by the fact that many sentences, often the most competent, are unable or unwilling to take the time to sit for cases lasting weeks or months. 17th day of August, and that's going to be that.
Week, I expect the state to answer, to respond to the motion that we filed, but I would like the opportunity to actually argue that in front of you.
Well, I mean, I don't know that I need a response from the state. I also don't need argument from you. I mean, I understand what you're asserting in your motion.
I mean, just today, Your Honor, they say that gang experts, for example, because that is one that we have gone to, that they have not been repetitive. But just today, and I wrote this down because it's just emblematic, just today, Ms. Love said, quote, our gang experts have testified to B replacing C. So here, there's a situation there where their gang experts have testified to the same thing multiple times. There's B replacing C. It's constant, Your Honor. And there's absolutely no reason that they should get to run this courtroom. Now, I'm not asking to run it. I'm asking you to run it.
I'm running it.
Okay? And you have the ability to put a time clock on the state. We're way past the time. I'm just going to finish real quick. We're way past the amount of time that we have told the jurors that they will be here. And that is a factor that you can consider. We told the jurors, now I remember 6 months. Other people have said we told the jurors 6 to 9 months. We're going to far exceed that. There's any number of reasons, and they're outlined in the motion. If you don't want me to argue it, I won't argue it, that we can put a limit on the state, or you can put a limit on the state.
Okay, I understand what is set forth in your motion. I understand the law. I understand what my powers are as the judge presiding over this case. I understand that cumulative evidence is unnecessary and maybe undue delay and a waste of time. I also understand that the state has a right to present its case, and that they don't have to be limited to just one witness per, count in the indictment. They have rights to. So I appreciate what you put forth there. I agree with it. I mean, it is granted. Okay. I will not permit there to be excessive, repetitive witness after witness saying the same thing, exhibit after exhibit showing the same thing.
Well, the relief I requested was to put a specific time, whether it be days or hours or however you want to do it. So if that's granted, I am thrilled.
Well, I'm not sure that I know at this stage, given that we have only not yet gotten through one incredibly long and somewhat painful witness testimony, what that time limit might be. I don't anticipate most of the other witnesses to be as long on the stand as this particular witness has been. And maybe I can get, maybe let's just ask the state right now, like time-wise, do y'all expect any of your other witnesses to take as long as Mr. Copeland has thus far taken?
No, we didn't expect him to take them.
But Your Honor, this is not the only witness that has
I
taken this
cannot do
long. anything
about what happened before I was the judge.
I appreciate that.
I just can't.
And I'm not asking you to. All I'm saying is that the state's saying that they don't expect other witnesses to take this long. There have been repeated witnesses that have taken weeks.
Okay, well.
And I mean, okay.
Let me drill down a little bit more. Okay. So are there any other witnesses that are going to have video interviews that are anywhere as near as this witness?
No, and
Okay.
for any witnesses that have taken more than a few days, there have been breaks, there have been pauses that have caused us to have to take that witness over a period of time longer than we ever anticipated.
And I hope we don't continue to have sound issues, but nobody can do anything about that, although I'm trying to at least get us a reasonable backup, which should have already been in place anyway. But all right, so I'm going to need an answer as to why there needs to be any other gang expert at all in some amount of detail. And y'all have the witness list, just like, you have the state's witness list. So if there's somebody else like the two extra gang experts that you all looking at the list and knowing the case backwards and forwards think, the person who's going to say this, somebody else already testified to all of these same things, then you'll bring it to my attention and we can go through and get answers as to whether those people or those witnesses or those exhibits are cumulative. But I can't know at this point in time. I haven't been in this case long enough yet to see what's reasonable for.
So basically what happened today was some minor motions and trying to get in evidence and then fighting to get evidence out, because obviously you don't want any of this in. You don't want no phone calls. You don't want none of this crap in. But when she was trying to explain the meme, I'm just like, Miss Love, I know you fry your chicken with nothing but salt and pepper. I'm sorry, you bake your chicken. You don't fry your chicken. You bake your chicken, shawty. Not only that, on top of that, bro, the judge, I don't believe you think that's a dope beat. I ain't gonna hold you. It's certain things that I'm just listening to that they making, and it's clear that it's nothing but slang. It's not slang that really means anything, but it's slang nonetheless that I think she don't get. I don't want to keep on boring y'all with all the clips and stuff like that, so I'll try to talk more. But essentially, there are things said in phone calls that happened today where she allowed him, but it was clear it really had nothing to do with nothing. And even the freaking, even Miss Love was basically like, well, if we find something, then we'll add it in there. And I'm just like, you out your damn mind. You clearly don't know what the hell this is about. But what you're trying to do is say, see, remember here. They brought in a video that showed Mook Tunk and everybody like that before the shooting, and she couldn't even present it right. The whole time I'm looking like, what the hell? So what happened was, before the murder of Donovan Thomas, there was a video that showed the alleged killers of Donovan Thomas entering a store like 7 minutes before and everything, as far as that goes. But instead of just using the damn cameras from inside of the convenience store, no, I gotta show that this also right here is a video of us showing us going into the store. Communicative evidence. So it doesn't matter. Like, what the hell? So basically, she already kind of knows, she's giving up the play already, that Moontu about to come in there and really say nothing. He ain't gonna give him nothing. He gonna pull a I ain't recall, I don't recall, and that's going to allow Miss Love, because she's gonna do the cross. It's gonna allow Miss Love to sit up there and start to try to bring in evidence. All right, cool. The video that I showed y'all with with Keith Adams, basically, the damn state is lying again. And it's like, y'all don't care. And I'm curious, I really want to know what the hell that officer gonna say when he basically gets on that stand and more than likely lies. Because the video is gonna show Thug just turning around like, what's up, man? And then boom. But the problem with it is y'all monitor his phone calls. Y'all monitor when they sitting up underneath the damn set, up under the jail, waiting to go upstairs to the courtroom. There was no communication. Thug isn't even in the same jail, by the way. I hope y'all know that. Thug is in a whole nother jail, and everybody else is in a whole nother jail on Rice Street. Thug is in Cobb. They in Rice. So Fulton County. There's no way he could have known any of this. And the way in which he acted, if he was smart, this gonna sound, hey, if y'all on that no Diddy Paul stuff, I ain't gonna lie. It would have made sense. just hear me out. If he would have put it in Thug's mouth the whole entire time, he'd have flicked it in his mouth or put it in his mouth instead of putting it in his hand. If it was really going to be that calculated. Because you wouldn't have been able to see anything. If he would have walked up and put it like a Tic Tac in his mouth, you really couldn't tell anything. Then Thug would have been able to swallow it, and so be it, and so be it, and so be it. I'm not saying that Thug knew anything about it. I'm damn near betting that he did it because he looked pissed off, in my opinion. Like, what the fuck? Are you serious? So, you got that shit going on, and then you got Brian Steele, who's going to argue for a new trial in front of the Supreme Court tomorrow. So we're going to see how that goes. If Brian Steele is as good as he basically is, he's going for a conviction reversal in front of the Supreme Court. We'll see. We'll see how that goes. He's going to be gone. I mean, I don't know, bruh. I don't know, man. We'll see how good Brian Steele is. But all in all, today in court was lame because the damn state literally showed up late. Didn't get a good stern talking to on camera. We don't know if they did in the back chambers or anything like that. But what happens is when we start off the whole entire trial, everybody just sitting there waiting, checks going up on everything, and nowhere to be found. Everybody's like, hey, are we having a court date today? Yeah, possibly. And I'm looking like, well, the defense is here. Everybody's here. What the hell? And then we disappear for like 20 minutes and then come back. And I'm just like, what in the F? But we'll see, man. Weinstein and his motion, I get it, but I ain't going to hold you. I cut out the part where he says, I'll be filing this motion again in 2 weeks. Because at the end of the day, it should not be taking this long. But with certain things that they claim is intrinsic, like how they try to argue today that anything done in jail is intrinsic, which means it's basically the beginning, like it's an ongoing RICO. No, you still have to prove that. You can't just say this is tied directly to YSL. If somebody gets caught with drugs and they sell, this is not a part of the goddamn RICO. And that's what Love was trying to argue today. You have no idea. This thing might be just a drug addict. So, did the pills that they find say YSL on it? Did the shanks that they find, the knives that they found, did all the contraband on it say YSL? Because if it doesn't, then what the hell are you talking about? And that's what she was trying to prove. We don't know if these scuffles or anything like that that happened in jail is a part of the YSL. As far as we know, somebody could have stole somebody's commissary, messed with somebody during their goddamn child time, or messed with somebody during the phone calls and stuff like that and got it cracking. And if you fight my homie, I'm going to fight your ass too. We have no idea to know if this actually is in furtherance of the YSL conspiracy. So for the state to try to argue that is pretty goddamn low. But then again, what can we actually expect? So at the end of the day, bruh, this trial is going to be a shit show. Tomorrow I'll have more clips for you guys, and then we'll proceed that way. But honestly, bruh, I'll see y'all back 12:30 in the courtroom, because today was nothing but hilariously entertaining bullshit. But if you disagree, then let me know why you disagree. You can put it out there. And I want you people who keep on saying, well, Sadie Nash, you're flip-flopping. If you watch sports, right? The first power rankings that they have, as the season goes on and continues to go on, those power rankings shift. Why do they shift? It's called new evidence. I get some of y'all want me to hold firm into certain things and all that, but that would be dumb. That would be as stupid as when we heard, oh, Big Nuts' dying words was, Thug killed me. And I'm sitting up here saying, damn, bruh, that's called dying declaration. Thug is done. But then it turns out, actually he said, man, I'm headed home. I'm going home, man. I ain't gonna make it. So you want me to hold on to basically saying that Thug killed Nut, and we don't know where the hell that statement came from? Opposed to two people that was by him while he was dying out? Yeah, I get you people who do that. Y'all, those individuals who you can't be wrong and you never apologize, and you never not going to admit that, you know what, you got it wrong. And if that's you, cool. This setting that shouldn't be flip-flopping like y'all say, but with new information comes new ideas, and I'm always going to do that. I'm not going to hold on to something that's going to make me look stupid in the end, especially when it's been proven wrong. But if you want people like that, then you be that person.